Hello, this is Court Watch with Alex Sawyer, and I'm excited to bring you the latest episode of my podcast, where I am joined by Jacob Hubert, president of the Liberty Justice Center. His organization is representing a client who is challenging the law that bans TikTok. The popular social media app is scheduled to go dark by January 19th unless the Supreme Court steps in to block the law from taking effect. The justices just heard arguments Friday over the legislation, which was passed with bipartisan support and signed by President Biden in April. It gave TikTok 270 days to divest from its owner, ByteDance, which is linked to the Chinese government. The law was passed due to national security concerns. The Justice Department claims the popular social media app collects user data and shares it with the Chinese government. TikTok and its users challenging the law say it is discriminating against them based on content, which runs afoul of the First Amendment. President-elect Donald Trump has asked the Supreme Court to halt the law from taking effect on January 19th to give his new administration more time to strike a deal between the free speech and the national security interests. Jacob will help break down how he thinks things will play out, given how quickly the justices took up the dispute. Thanks, Jacob, for coming out to the studio and chatting with us and telling me a little bit, first about your organization and your client, Based Politics. What do they do?
I'm president of the Liberty Justice Center, which is a nonprofit public interest law firm that brings lawsuits all over the country to protect people's constitutional rights and enforce constitutional limits on government power. And when we saw that President Biden was likely to sign this law effectively banning TikTok, we wanted to do something about that because we recognized that as an unprecedented, sweeping restriction on Americans' right to free speech. And so we looked for an appropriate client to challenge that, and we were happy to get connected with our client, Based Politics, which is a nonprofit that uses social media, including TikTok, to spread ideas related to individual liberty and economic freedom, free markets, to young people in particular.
Right.
And they've been especially successful at doing that on TikTok because TikTok connects them to people who would be interested in their videos, but who don't necessarily know they'd be interested in their videos until TikTok shows them to them.
Right.
So it's been very important to their work. And so that allows us to go to the court and point out if you shut down TikTok, that is going to destroy the ability of our client and countless others like them to connect with their audience in this forum for speech.
Right. And so I remember I was looking at some numbers, and I think it's 39% of users of TikTok are in 39 and younger, or in their 30s or younger, right? Something like that. So it's definitely young adults that are able to use this platform. That's a major segment of the American population that get their news from TikTok as well. I think it was 17%. So we're talking a lot of people who in 9 days might not have access to what could be their most used app on their phone, correct?
That's right. And the government will argue in this case, well, they can say whatever they want. They just go somewhere else and say it.
Right.
So this doesn't affect their speech. But that's not true. I mean, they do say things on Instagram and Twitter, and they've had some success there, but it's not the same as TikTok. TikTok allows them to reach this Gen Z audience that they can't connect with anywhere else, that looks to TikTok and not other platforms to get ideas and news.
Right. Okay. And then one of the things I want to talk to you about, I know you were in the courtroom, so was I. Arguments were very interesting, lengthy. I think they were scheduled for 2 hours. We went, 3, close to 3?
Yeah, about 3.
And there was definitely interest from both wings of the court. I thought they had tough questions for both sides. So what did you think? What did you make when you left? What were you thinking?
Well, I mean, when I heard them ask our side questions, this doesn't sound so good. They've got really skeptical questions. But then I heard them ask questions the other side. It's they got tough questions for them too.
Yeah.
So that's good. But it's very hard to know where anybody's going to come down on this. Going into it, a lot of cases you go in and you have a sense of, well, the conservative justices will probably think this,
Exactly.
and liberal justices this. Going into this one, it's just not clear at all. And coming out of it, it's still not very clear. I think it's from Justice Gorsuch asked the kind of questions that would make me think that he's seeing the points that we're making. But the others, they didn't signal very clearly. They asked things that suggest they could go either way.
Exactly, and I think some of them asked just as hard questions to each side. Just when I thought I knew what side of the coin they were on, I was wrong. But
exactly.
So I guess we'll start with the first part of the argument was Mr. Francisco was up, former Solicitor General was up representing TikTok. And I thought he ran into issues with some of the justices asking about, so TikTok is owned by ByteDance, and they seem to focus on that this law is targeting ByteDance, not necessarily TikTok. Like I think someone used the idea that it would be like incidental effects was like the phrase that this law could have. But ByteDance could always divest, that sort of thing. So that kind of made me think, like they're trying to say maybe there's no First Amendment issue there, correct? But the fact that you have users, does that change the equation? American users.
Well, it should. I think TikTok's case is fine, but I think ours is even better. Because with TikTok's case, they can make the argument that, this isn't about speech, this is about ownership. We just don't want a company beholden to China to own this thing.
Right, and that's what the government was.
But you could still have it and say what you want. Now, there are
Right.
reasons why that's wrong. But however that is, when it comes to TikTok users, it most certainly is a restriction on their speech, their ability to associate with essentially the editor and publisher that they want to get their speech out there, and it serves as a forum, and taking it away infringes their rights, whether you do it in the form of requiring ByteDance to divest TikTok or whatever. And it's not just about ownership also, because even if TikTok were sold to a U.S. company, this law tells them you can't use the TikTok algorithm anymore, which is maintained in China. So you cannot have the mix of content that you have now. You can't have this unique platform anymore. So what would be created from that would be something different that wouldn't allow our clients and so many others to do really what they do now.
Right. And I know, so like for some of our audience that haven't necessarily been following the case in depth, it's been TikTok and users, so two kind of separate cases that were consolidated under one for arguments for purposes today. And so with the DOJ, I thought they definitely had the Solicitor General had a harder time, I think, talking about the users. I think it was so much confusion with like the argument that it's not content based, but yet the government's concerned with content manipulation, right? So can you kind of explore that? Like there was also questions about, I think, data collection.
Right. So the argument that this isn't a content-based restriction on speech is really weird when one of their two justifications for this is, well, China could have them manipulate content in a way that the U.S. government doesn't like.
Right.
So, I mean, if the justification is about content, well, then obviously the law is about content. And this isn't just about ownership, it's about speech. They're targeting it because of the speech. Now they're focusing on, well, China might alter the combination of videos in some way in the future we don't like. But also the people who passed this made clear that one reason they want to ban TikTok is they don't like what people are saying on it right now. Mm-hmm. It's all about the speech on there. And that's why this law singles out TikTok. It authorizes the president to ban other speech platforms like it in the future, and does nothing to other apps that may present similar concerns about China being able to get people's data, but don't have that kind of speech component. It's the speech that they are targeting here, and it's speech that's going to be restricted as a result of this. And you mentioned the data aspect of it.
Yeah, I wanted to ask you about that because you mentioned Gorsuch, and he suggested that there was also something I picked up on, and the Solicitor General cited, I think it was a sealed appendix, and it seems like, there's this secret evidence that they're talking about. Like, has your side been able to see what the government's so concerned about? Or because us in the press, we're wondering.
No, so in the D.C. circuit where this case started, the government, when it submitted its brief, submitted exhibits, which were declarations of government officials, and many paragraphs of those were blacked out. And then in the government's briefs, whole pages, one after another, were blacked out. And they said, well, that involves classified material. And so not only should the public not see that, according to the government, we couldn't even see it either.
Right.
And so the government is presenting this stuff to the court that supposedly justifies this law, but we have no way to respond to that because we can't see it. It's a very weird thing where this law is set up to send you directly to the Court of Appeals. So there's no usual development of evidence where you would examine witnesses and you could test the evidence and so on. So not only do you not have that, then the government wants to say, also, you can't even see our evidence, which is just extraordinary,
right?
And especially in the First Amendment context, when you're talking about shutting down the rights of millions of Americans. So when the D.C. Circuit issued its opinion, it sidestepped that by saying, we're just basing this on the public stuff. We're not looking at the redacted, classified stuff, which was submitted to the court uncensored. They said they're not looking at that. And now that the issue really isn't in front of the Supreme Court. And so it came up, that Justice Gorsuch was sort of disturbed by the government's attempt to rely on secret evidence.
He wasn't the only one. I think Alito also raised an issue with that and said, well, the other side says that they don't get to see this. I remember when the Solicitor General was up there citing the pages, I saw, I think it was Mr. Fisher, which represented some of the users in argument, right? And then it was Mr. Francisco. They both kind of like, this is what you don't get to see if you're listening to audio, but their heads were kind of like whipping back, looking at each other. So you definitely, there was this sense that it was like only one side has information. And when you're talking about a First Amendment issue like you are, can you explain why that's important? Like there's different levels of scrutiny. So for our non-lawyers listening, what you really want is them to say there is First Amendment at play here, and so the government would have to reach the strictest level of scrutiny, correct? Can you kind of explain that in like non-legal terms?
Right. So when someone challenges a law for violating the First Amendment, if that law restricts speech based on its content, based on like what it says, whether by subject or by viewpoint, and we would say also by speaker, then that should get the highest level of First Amendment scrutiny, where the government would have to show that what it's doing serves a compelling governmental interest, which is the highest level of governmental interest. There aren't very many of them. And not only that, but also it's narrowly tailored to serve that interest, meaning the government couldn't serve that interest in some other way that wouldn't infringe on people's rights as much. And that's kind of a weird thing because, I mean, the First Amendment just says Congress shall make no law. It doesn't say, well, unless you have a really, really good reason and you tailor it. Well, but that's how it is. Like, it's kind of generally the best you can do is this strict scrutiny. And so the government here says, well, we have a compelling interest in national security. That's a compelling interest. And a lot of the fight then is really over, well, is this really tailored to serve your interest in national security? Could you do this in some
more
other
narrow way, right?
That doesn't like shut down everybody's speech?
Yeah. And so with that said, what are some more narrow ways? I'm sure you've thought about it.
Right. Well, if you're talking about data privacy, which is one thing they rely on, we've talked about that a couple of times here, like when they, if they get in trouble on the content manipulation part of it, well, then they pivot to data privacy because that sounds less like it involves trying to control people's speech. That does sound like a more legitimate security concern. And what they could do about that is they could pass a law that says if nobody can be giving American users data to China. And that's it. Or, to a foreign adversary, whatever they want to say about what you can do with data, they could do that. And that wouldn't shut down everybody's speech. That would just restrict how TikTok or anybody else could use people's data. And then on the, content manipulation side, we would say that's just totally illegitimate. The government shouldn't be getting into that at all. But if you are concerned about that, well, it is legitimate, although we don't think so, well, you could put a warning on it that says, this might be manipulated by China. We don't know. They could be, and so beware to, consider that when you look at this. I don't think that's a very good solution in that it could be misleading because like our client advancing ideas about free markets, that has nothing to do with China. Right, China, I don't think likes those ideas. And so if you put a warning on it, that could actually give people the wrong impression. But Anyway, that still wouldn't be as bad as just making it so nobody can speak on TikTok at all.
Right. And so one of the things when I was there, I mentioned the beginning of the arguments. I was like, oh, there might be some justices that don't think there's any sort of First Amendment issue because of ByteDance, right? And then there were some that, well, I recognize that there's speech and I recognize there's content, but they kind of acted like, well, there's national security concerns. But when the Solicitor General got up, those really weren't articulated, or if they were, they're in some sealed documents that we weren't able really to see. So with that kind of in play, where do we go? There were questions about a preliminary injunction that the justices could do, an administrative stay. Can you explain, what are those? How would those impact the law is set to go in effect in 9 days? So what would that mean?
So courts issue a preliminary injunction sometimes if a party, say, challenging a law, shows that it's likely to win in the end on the merits of its constitutional claim, and it would suffer some irreparable harm if the court doesn't block the law temporarily while the court considers the case. So a preliminary injunction would normally block a law while the court considers the case until it reaches a final decision one way or the other. And normally in issuing a preliminary injunction, a court would have to issue an opinion that says, we think the plaintiff is likely to succeed on the merits, and here's why their claim is really strong, and they'd also suffer a lot of harm. And with constitutional rights, that's easy. If you're losing your constitutional rights, that's irreparable. And so therefore we're issuing a preliminary injunction. And I think the government thought that wasn't appropriate here because, well, the government's view is we're not likely to succeed on the merits. And so the government's view would be, well, if it's just about buying a little extra time, maybe Trump can work this out when he takes office. You shouldn't do a preliminary injunction because we don't think you should say this law is constitutional. But a way the court could avoid that would be by just issuing, as Justice Alito suggested, an administrative stay, which isn't really giving an opinion on the likelihood of success or anything like that, but just the court essentially saying, we're going to pause this while we figure this out.
And so just because we're talking about a change of administration, and we know President-elect Donald Trump has been, he filed a brief. He says it wasn't on behalf of either party, but he's kind of looking for a pause so he can come and hopefully strike some sort of compromise is what I guess he's looking to do. So if that were to happen, then his new Solicitor General, I would guess, would come in and file new briefs. Is that how it would work? Could there be a rehearing?
There could be. There wouldn't have to be, but the court could ask for that. And certainly, Trump, through his Solicitor General, could ask for that. But the problem is this law takes effect on January 19th, and Trump doesn't take office until January 20th. And so that means TikTok does have to shut down effectively on January 19th. And the law also would allow the president to give TikTok an extension of its deadline to be divested up through January 19th. But Biden isn't going to do that, and Trump isn't in a position to do that. And once he takes office, you could argue that, well, time is up. You can't extend it now. But the government wasn't firm on that. The government was asked about that today and said, well, we're not sure. Sometimes courts have allowed that, but we haven't really looked into that. We're not sure. And so Trump could try to do that. Whether the administrative stay happens or not, Trump could, of course, try to pass a different bill through Congress that addresses national security concerns without suppressing speech.
So a stay and an injunction, though, would both pause the law from...
Yes.
Okay, that was one of my questions. I guess if they were going to issue a preliminary injunction based on what you described, then that would be a good sign for you all, that means that that's where their opinion, it looks like, would be leaning on your side, correct?
Yeah, that strikes me as relatively unlikely in as much as if they're going to wait to issue a final decision, you would think that would be in part because, well, this is a really big issue and we should take our time and not write into an opinion as fast as we've ever done. And therefore, they wouldn't want to write a preliminary opinion that kind of, sets out what they're thinking about this. The whole point would be to take their time.
Right.
And also, if the point is also to just give President Trump time to try to resolve this so that the Supreme Court doesn't have to weigh in this difficult case. And of course, a lot of times courts prefer to avoid addressing difficult constitutional questions if they can. Then the administrative stay would make sense there, where they don't have to say anything about what they think about it, and they can just hope that it goes away.
And sometimes when I listen to arguments, or I'm like, oh, well, this might be one of those cases that we get a few different opinions, it usually takes a while for all those opinions to get written. And so the fact that we're looking at 9 days also suggests that they might want to issue that administrative stay and give themselves even more time, I guess. And then, of course, we would see what happens, 2 weeks from now when you have a new Justice Department. On the flip side, that if they were to not do what we're talking about right now and to go ahead and affirm and side with the Justice Department, what would that mean for your clients?
Well, it would mean they can't use TikTok anymore. It won't be in the U.S. app stores, so nobody can download it. And U.S. companies can't provide services to TikTok in the U.S., can't host it and so on. And as far as anybody knows, the result of that is effectively that it goes down. Now, could you log into the website and maybe, use a VPN and get to it some other way? Well, maybe you could do that. But for practical purposes, for most people, it's going to not be an option anymore.
And one of the other things that came up was like this, we talk about a lot of free speech, like First Amendment free speech rights, but what about freedom of association? Is that at play also? Because, who's the government to say who you can associate your speech with and not?
Right, yeah, there is a freedom of association component to that. I mean, people who want to publish things should be able to associate with the editor and publisher of their choice. And so that does come into it as well.
Is there a way that you talk about like how there wasn't much of a record like developed at all with, you talked about trial, lower court, trying to get more evidence. Would there be a situation where there could be more time for that to play out? Like say change of administration, could that go back down to lower courts? How would that, would a rehearing have to happen at the Supreme Court?
If more evidence were developed below, like if they sent it back?
Like would that ever be a possibility in the way that the timeline of this case has gone?
I don't think so. It's a very weird law in that, again, it says you've got to challenge it in the appellate court for the DC Circuit, and where they don't have trials, you don't develop evidence, and it doesn't say what kind of procedures that court should follow. And so it's theoretically possible that the Supreme Court could say, the lower court should have developed more of a record. We don't have enough to work with. Nobody's asking for that. I think that's very unlikely.
Okay.
But if that did happen, then yes, it would play out again in the DC Circuit and then surely go back to the Supreme Court.
Thank you so much for your time and breaking this down for us. I really appreciate you coming all the way out here, and good luck to you and your clients.
Thank you. Happy to be here.
Thanks for tuning in to the latest episode of Court Watch. If you have not subscribed yet to this podcast, please do so, and also feel free to email me interesting questions or topics you want explored about the legal reporting world. I'll do my best to answer them during each episode. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com